Thank you all for joining us this evening. Are we all ready up here?
Yes, sir.
All right. Hi, everyone. My name is Jonah Dross. I'm the Senior President of the Federalist Society at the University of Miami.
Hi everyone, I'm Emily Nadell. I'm the Junior President of the Federalist Society at the University of Miami.
Good evening and welcome to our panel on the Bush versus Gore election recount legal proceedings. We are joined in hosting today by the Litigation Skills Program and its amazing director, Lydia Sanchez. As this is our last event of the semester, I'd like to take a moment to thank all of our great board members who helped make today possible. Emily, Carter, Justin, and all of our class representatives. We'd also like to thank Ashlyn Gawadi and Annette Hughes for all their assistance in making this event happen for the school. Before we hand the conversation over to Judge Miller, we would like to remind everyone about the missions and goals of the Federalist Society.
In its mission and purpose, the Federalist Society is unique by providing a forum for legal experts of opposing views to interact with members of the legal profession, the judiciary, law students, academics, and the architects of public policy. The Society has redefined the terms of legal debate. Our expansion in membership, chapters, and program activity have been matched by the rapid growth of the Society's reputation and the quality and influence of our events. We have fostered a greater appreciation for the role of separation of powers, federalism, limited constitutional government, and the role of law in protecting individual freedom and traditional values. Overall, the Society's efforts are improving our present and future leaders' understanding of the principles underlying American law.
The Federalist Society provides opportunities for effective participation in the public policy process. The Society's ongoing programs encourage our members to involve themselves more actively in local, statewide, and national affairs, and to contribute more productively to their communities. Now we will introduce and hand the conversation over to Judge Bronwyn Miller.
Judge Bronwyn C. Miller currently serves as a judge on the 3rd District Court of Appeals. She received her Juris Doctorate cum laude from the University of Miami School of Law and Bachelor of Arts from Barnard College at Columbia University. She was a prosecutor at the Miami-Dade County State Attorney's Office from 1997 to 2005. There, she served as training director and a division chief in the felony unit and attained an AV rating by Martindale-Hubbell. In 2005, Governor Jeb Bush appointed Judge Miller to the Miami-Dade County Court. In 2010, Governor Charlie Crist appointed her to the 11th Judicial Circuit Court. In 2018, Governor Rick Scott appointed her to the 3rd District Court of Appeals. Judge Miller has previously served as an adjunct professor at Florida International University, and she is currently an adjunct professor at the University of Miami School of Law and an advisor to the Civil Jury Project at New York University School of Law, a member of the Appellate Court Technology Committee, a member of the Commission on District Court of Appeal Performance and Accountability, and a member of the Rules of General Practice and Judicial Administration Committee.
She has previously served on the Appellate Rules Committee and taught at Florida's Conference of County Judges, Florida's Conference of Circuit Judges, Florida Judicial College, and the College of Advanced Judicial Studies. She is the co-author of Authentication of Digital Photographs Under the Pictorial Testimony Theory, a response to critics, Florida Bar Journal. A Prolific Landscape, the Admissibility of Social Media Postings, Florida Bar Journal. And Prosecutorial Ethics, Beyond a Reasonable Doubt, the Prosecutor. Judge Miller is the recipient of the Alan R. Schwartz Professional Excellence Award, Florida Association of Women Lawyers Maddie Bell Davis Award, Legal Services of Greater Miami Equal Justice Leadership Award, Judge Steve Levine Award, Miami-Dade Commission on the Status of Women in the Company of Women Outstanding Woman in Government Award, Millennium Movers Celebration of Urban Professional Women Mover and Shaker Award, Women Who Rock Award, Conference of County Judges Leadership Award, South Florida Hispanic Chamber Community Service Award, the Miami-Dade Bar Association Young Lawyers Section Judicial Vanguard Award, and the Ronald Reagan Judicial Excellence Award. She has also been recognized by the Florida Senate for her work with the Miami-Dade County Grand Jury. Please join us in welcoming Judge Bronwyn Miller.
Thank you very much. Welcome to the 25th anniversary of the United States Supreme Court's landmark decision in Bush versus Gore that settled a recount dispute in Florida's presidential election between George W. Bush and Al Gore. For those of you who recall the unprecedented events surrounding the November 7th, 2000 presidential election, it is hard to believe that it's been a quarter century that has already gone by. But many of you were not yet born when these historic events unfolded. It is truly an honor and privilege to be here this evening and have the opportunity to learn more about this historic litigation from some of the most talented lawyers in the entire country. These lawyers could be billing their valuable time, but instead have chosen to give you the benefit of their wisdom. I would first like to thank Emily and Jonah for representing the University of Miami Federalist Society chapter. Thank you for dedicating your time and coordinating this discussion. I'd also like to recognize Jeannie Jontiff, the Director of the Litigation Skills Program, who's with us this evening. She's accompanied by Lydia Sanchez, who works tirelessly in the Litigation Skills Program as well. And I'd also like to recognize a legend who's in the audience, Judge Paul Huck, along with Professor Bernie Pastor, who's with us as well. As with most Federalist Society programs, this panel features people dedicated to preserving individual rights from both sides of the aisle. Now, on to our esteemed panelists. I'm going to begin, going in no particular order, with Bobby Martinez. Bobby Martinez is a lawyer, a shareholder at Colson, Hicks & Edson in Coral Gables, Florida. He's a very esteemed attorney. He has a lot of information about him, but he told me that he wanted me to say, above all, he's a Miamian, he's a lawyer, he loves Miami, he loves this country, and he loves the law. But I'm going to tell you a little bit more about him.
That's it. That's all, and I love my wife.
Okay. We've got it all covered and it's being recorded.
That's it.
Bobby is a widely recognized litigation attorney, and as I told you, a partner at Colson Hicks. He has successfully handled high-profile business litigation, products liability, and white-collar criminal defense matters at the federal, state, and international levels. He has also served as co-lead trial counsel in several anti-terrorism cases. He's a former U.S. attorney for the Southern District of Florida. He has a record of active service in education, both in his home county of Miami-Dade and on the state level, serving as a vice chair and as a member of the State Board of Education for several years. Currently, he serves as a chair of the Miami-Dade County Public Schools 21st Century Bond Advisory Committee. Mr. Martinez has also served as a member of the Florida Taxation and Budget Reform Commission in 2007 and 2008, and chair of the Commission's Government Services Subcommittee, former chair, Florida Federal Judicial Nominating Commission, former chair of the District Board of Trustees of Miami-Dade College, general counsel of Governor-elect Jeb Bush's transition team, and chairman of Governor-elect Charlie Crist's transition team. Mr. Martinez was honored with a special recognition award from the United States Department of Justice Civil Rights Division and received the Florida Supreme Court's Voluntary Bar Association Pro Bono Service Award for the Florida Bar. The Miami Coalition of Christians and Jews also honored Mr. Martinez as a Silver Medallion honoree for his humanitarian work, advancing the understanding and respect among all cultures, religions, and races. Mr. Martinez received his Juris Doctor degree from the Georgetown University Law Center, where he was on the Dean's List. He holds an MS in accounting and a BS in economics from the University of Pennsylvania, Wharton School of Business. Please give him a warm welcome. We have Steve Zack. Steve is a member of the firm's executive committee at Boyce Schiller. He's a board-certified trial lawyer and a widely recognized leader. He is past president of the American Bar Association and was the first Hispanic American to assume the ABA presidency. He was also the first Hispanic American and the youngest person to become president of the Florida Bar. He has served as president of the National Conference of Bar Presidents and as chair of the ABA's House of Delegates, one of the nation's most influential positions on matters relating to the legal profession. He is a fellow of the International Academy of Trial Lawyers, and he received a Lifetime Achievement Award from the American Lawyer. Mr. Zack's main practice as a civil trial lawyer is in the areas of products liability, class actions, and federal multi-district litigation, complex commercial litigation, arbitration, international law, and voting rights. He was nominated by President Barack Obama for the position of alternate United States representative to the 68th session of the General Assembly of the United Nations, and he served as senior advisor to the United States State Department. He is also a member of the Council on Foreign Relations. Mr. Zack was nominated by President Biden to serve as a member of the President's Advisory Committee on the Arts. And he was also Governor Bob Graham's general counsel, and he served on the Constitutional Review Commission along with Mr. Martinez.
And we were partners.
And you were partners, correct?
I was his
We're gonna hear a
I was
little
his
about that, I
associate.
think.
I was his associate. Nobody's associate.
Next we have Raquel, Rocky Rodriguez. And I'm looking at this little mini bio, she's so humble.
This is my election law bio.
Okay. Raquel Rocky Rodriguez is a litigation shareholder at Buchanan, Ingersoll, and Rooney, and shares the firm's Florida offices. From 2002 to 2007, Ms. Rodriguez was general counsel to Florida Governor Jeb Bush. She provided counsel on more than 200 judicial appointments across all levels of the Florida judiciary and worked on some of the most critical issues facing the state. These included negotiating the then largest economic incentive deal in state history, the $310 million grant for the expansion of the Scripps Research Institute into Palm Beach County, the Terry Schiavo case, and the suspension and removal of former Broward Supervisor of Elections, Miriam Oliphant. Ms. Rodriguez was Governor Bush's personal lawyer and remains his personal lawyer and has been since his return to the private sector, and was deeply involved in his presidential campaign. In 2000, she was one of the lead lawyers for George W. Bush and the Miami-Dade Republican Party in the Miami-Dade recount, and has subsequently represented presidential, gubernatorial, and Senate and congressional candidates through various Florida election cycles. Rocky brings over 3 decades of state and federal experience in complex litigation, international, governmental, and political law, and she's a prolific traveler. That's not her bio, but I'm not. Please give her a warm welcome. Next, we have Benedict P. Kuehne. Known as the Iron Lawyer for success and accomplishments in complex, protracted trials and appeals, as well as for being an Ironman athlete. That includes 140.6 miles of swim, bike, and run. Benedict P. Kuehne has made his formidable career in trial and appellate courtrooms throughout the state of Florida and across the nation. While best known as a white-collar criminal defense and civil rights lawyer, he is also one of the premier election law specialists in Florida, having represented Vice President Al Gore and the Gore-Lieberman Recount Committee as trial and appellate co-counsel in the 2000 election recount trial and the appeals to the Florida Supreme Court, the 11th Circuit Court of Appeals, and the United States Supreme Court. Ben is often referred to as a go-to lawyer for public officials and professionals involved in investigations and inquiries, disciplinary and ethics proceedings, and criminal litigation. Mr. Kuehne is a past president of the Dade County Bar Association, a former member of the Board of Governors of the Florida Bar, a past president and life member of the Florida Association of Criminal Defense Lawyers, Miami, and a founding and life member and past board member of the Florida Association of Criminal Defense Lawyers. He served as chair of the Criminal Law Section, the Appellate Practice Section, and the Council of Sections of the Florida Bar, was president of the Florida Council of Bar Association Presidents, and chair of the Appellate Certification Committee and the Criminal Certification Committee of the Florida Bar. He is triple certified by the Florida Bar in criminal trial practice, appellate practice, and criminal appellate law, and by the National Board of Trial Advocacy as a criminal trial advocate. He received the Sally Golden Award for lifetime contributions to the criminal justice system by the criminal law section of the Florida Bar. He is also credentialed as a certified fraud examiner, life member, and a certified legacy advisor, and is recognized by the Mosaic Miami, MCCJ, as a recipient of its Silver Medallion Humanitarian Award. Please give him a warm welcome. Marcos Jimenez. Marcos Daniel Jimenez is a partner with Leon Cosgrove Jimenez LLP. He's a former United States attorney for the Southern District of Florida. Mr. Jimenez is recognized for his proven track record of success in complex business litigation and white-collar defense. As the presidentially appointed and Senate-confirmed United States Attorney for the Southern District of Florida, Mr. Jimenez led approximately 230 federal prosecutors across all areas of federal criminal law enforcement in one of the nation's largest federal districts. During his tenure, he served on the Select Attorney General's Advisory Committee of U.S. Attorneys, headed the nation's largest organized crime drug enforcement task force, and concentrated on anti-terrorism efforts in the wake of 9/11. Earlier in his career, he served as an assistant United States attorney, successfully first chairing criminal trials and appeals. Mr. Jimenez graduated in the top 1% of the University of Miami School of Law class, served as an associate editor of the University of Miami Law Review, and is a member of the Iron Arrow, the university's highest honor. He's also been recognized in various publications, including Chambers USA, where he is ranked in both commercial litigation and white-collar crime and government investigations. Chambers USA describes Mr. Jimenez as a brilliant lawyer who is very comfortable in the courtroom with a particular ability to hold the judge or juror's attention. It has also described him as a great trial lawyer, fearless in the courtroom, which makes him a dangerous opponent. Previously, the National Law Journal featured him in its annual winning issue for his rare trial victory in a deceptive trade practices case brought by the Florida Attorney General. Please give him a warm welcome. Now we have Kendall Coffey. Last but certainly not least, Kendall Coffey is a founding member of the law firm Coffey Burlington PL, based in Miami, which handles matters in Florida and throughout the entire United States. Mr. Coffey served from 2009 until 2019 on the Federal Judicial Nominating Commission for South Florida, appointed by both of Florida's United States Senators, and was the chair of the Southern District Conference from 2009 to 2017. Mr. Coffey previously served as the United States Attorney for the Southern District of Florida, the nation's largest federal prosecution office at that time. As United States Attorney, he was responsible for thousands of federal criminal prosecutions, as well as civil lawsuits involving the United States. After his public service, he resumed private law practice with major litigation roles in such high-profile cases as the Elian Gonzalez international custody battle and the 2000 United States presidential election recount. Today, Mr. Coffey's practice areas include governmental issues, business disputes and litigation, national and international litigation, fraud cases, contract and loan agreement enforcement, compliance issues, and defense and government investigations. His firm represents businesses as well as individuals facing financial and personal disputes. A frequent teacher and guest lecturer, he has been a guest legal analyst, providing legal commentary over the years for international networks, CNN International, Telemundo, Univision, national networks, CNN, CNN Headline News, Fox, CNBC, MSNBC, NBC, and local television, Telemundo 51 and Univision 23. He is also an adjunct faculty member at Florida International University School of Law, where he has taught litigation, administrative law, and negotiations. Additionally, he has taught Florida constitutional law, trial advocacy, and international corruption at the University of Miami School of Law and Florida criminal procedure and white-collar criminal law at St. Thomas University School of Law. Mr. Coffey has been recognized by Best Lawyers in America in multiple categories, including being named the 2024 Lawyer of the Year in Miami for professional malpractice. He is consistently recognized as one of Florida Trend's legal elite, a Florida super lawyer, and a top lawyer by the South Florida Legal Guide. He was also named one of the National Law Journal's Lawyers of the Year for 2000 as a member of the Gore legal team. Though all cases vary, his experience includes lead trial and appellate counsel in historic voter fraud cases, lead counsel for major insurance companies in defending RICO actions, lead counsel in 7-week federal criminal trials, and you name it, he's done it. Please give him a warm welcome. So let's begin by setting the stage for Bush v. Gore. Panelists, if we can go one by one and you can tell the audience members about your involvement, beginning with Ms. Rodriguez, how you got involved in the case, where it took you, and then we'll talk about some more specific areas.
Okay, my involvement began before we even knew there was going to be a dispute over the election. I was I guess in 2000, I was a junior partner at Greenberg Traurig. I had just returned from a fabulous 2 years working in London and traveling the world, running an international law firm referral network. I'd been at Greenberg already before that 12 years, and when the Bush campaign was ramping up in early 2000, a former partner at Greenberg who was very close to the family, Sue Cobb, who we all know, asked me if I would co-chair the Bush-Cheney campaign, Lawyers for Bush-Cheney in Florida. I had no idea what that was, but they wanted to have Lawyers for Bush-Cheney, and so I kind of was already baked in, and they said, okay, on election day, we want you to be at the Supervisor of Elections office, wait there and see them bring in the ballot boxes. So when people were voting, and you're gonna hear about the punch card ballots, those would all be collected and put in a locked metal canister that was probably the size of a portfolio, probably, I don't know, 11 by 14 or something. And they would be brought in and taken upstairs to the Supervisor of Elections office, which used to be there. And so a colleague of mine from work and I were camped out in the lobby of the county building. Professor Pastor knows that location well. And we had a little TV and we were watching the returns and watching them bring things in. And Frank Shepard, who was a lawyer at the time, he's now a retired appellate judge, was waiting in the counting room as one of the election observers to watch the supervisor's office process the ballots. And they called the election for Gore right around after 8 when the precincts closed in all the Florida regions. And we were told, don't leave. We hung around. 10 o'clock, 11 o'clock, the media says, oh, maybe it's not Gore. And then it was back in the questionable column. And then they said, go up to the counting room and help Frank. So I was there waiting to see if anything happened. The Gore guy had to come back from the party. And he was standing there with me. And I was calling Tallahassee and then Austin with reports periodically as to what was going on. And I think like around 2 in the morning, they said, okay, we're done for the night. We'll be back tomorrow. At that point, they processed everything, and President Bush was ahead. Of course, you still had the absentee ballots that were still being canvassed. You still had the military overseas ballots that had to be, they had an extra 10 days. And we didn't have provisional ballots then. So that was about what was waiting. So I go home, I turn on the TV, and I see Bob Butterworth, the Attorney General, says, I'm calling for a machine recount of all of the ballots. And I go, wow, I better go there in the morning. So I slept like 3 hours and I went back and it's pandemonium. One of the first people I see is Bob, and I go, good, I'm glad Bob is here. And so we just started at that point, trying to figure out what was going on, get information. So that was day one. The Bush legal team and the grassroots people, the Deputy General Counsel, Kevin Martin, somebody had them call me, and I met them at the supervisor's office. I don't know if it was day one or day two. I just kept going back every day. Nobody told me what to do. I just kept showing up. And then right when they're there, Barry Richard gets hired. We see an email that comes from Cesar Alvarez saying, hey, we've just been hired by the Bush campaign. And I go, good, I don't have to resign from the firm. Because I was going to be in this litigation no matter what. I don't care, I was going to be in it. So I was very happy that we were officially on board. And so we were, Bob was my partner then.
No, I had left.
No, you had left. Miguel DeGrande was my partner, but we had been former partners. And I'm former partners with Kendall, who was my boss, and Mark and I were associates together. So we're all connected. And Steve is the best friend of my mentor, Alan Diamond. So I grew up knowing Steve. And I got to know Ben through this process, and we've been working together on cases in recent years. But anyway, I digress. So I'm just gonna, stop there, but our office at Greenberg became the hub for part of the litigation. We had a lot of people from the administration coming and going, and a lot of the volunteers were coming and going through there. Now 11th Circuit Court of Appeals Judge Barbara Lagoa was an associate in our firm, and she was part of our team, and her husband, Paul Huck Jr., hello, family, was also volunteering. We had a lot of people helping us, so that was my entree.
Thank you very much. On to you.
So let me demystify it, because how this comes about, we all have different memories, we all do different things, so it's been a long time. Fortunately, I saved a lot of papers, so I kind of have I went through them this afternoon. But let me demystify it. So my involvement. I'm very close to the Bush people. Jeb and I went to high school together. I got to know a lot of the young people in this administration because I was his general counsel during that transition. So I became very friendly with the Jeb Bush people. So I did all that with Rocky there during the recount then, the machine recount. And then on November 9th, I go to Jillian Inman's office. Jillian Inman was the person in charge of the Bush campaign in Florida, and she was over here at the Daytran Center. And I'm with her, and she gets a copy of a fax that was sent to her. Maybe it was sent by Mary Greenberg, who, by the way, I want to do a shout out to Mary, who has passed away. Mary was a very honorable guy throughout this process. He was the deputy county attorney running the show. Mary Greenberg, great guy. So, on November 9th at 12:27 p.m., we get from the Miami-Dade County Democratic Party a letter addressed to David Leahy, the supervisor of election. This is how these things happen, guys. There's literally, you don't have to necessarily be in the Supreme Court being a law clerk, all of a sudden a big case comes in. I was just visiting a friend. Jillian, how's it going? And she gets this fax. It's a copy of a letter from Joseph Geller, representing the Miami-Dade County Democratic Party, addressed to David Leahy at 12:27 p.m. Request for manual recount, 12:27. Then a 3:01, written request of the County Canvassing Board of Miami-Dade County. Then he rescinds that. He withdraws that and he amends it. And I'm with Jillian and said, what the heck is this? So we said, well, we got to respond to this. So I go find Mary Ellen Miller. Mary Ellen Miller was then
She rest in peace too.
she was the head of the local Republican Party. She has no idea any of this stuff is going on. So I go, geez, we have to get Mary Ellen to sign a letter saying, if you're going to do a recount, we want to be there. So I draft a letter for Mary Ellen Miller. I go see her. We put it on Republican Party of Dade County stationery, and we send it into David Leahy, supervisor of election, who was terrific, a real public servant, did a great job. And that's how I get involved. And one thing led to another. That was on November 9th. The first hearing, Kendall, that was in Steve, that was on November 14th.
It was a Monday, wasn't it?
November 14th, and the Monday.
Before Don Meadowbrook's?
No, I only was involved in the Miami-Dade Canvassing Board. So
Okay.
this was the Canvassing Board. November 14th.
Yeah, that's right.
And the board was, you know, I've become very friendly with some of them. Marion Lair, a judge, now retired, Judge Larry King Jr., and Supervisor of Election, Leahy, David Leahy, who was excellent. And then we had a hearing, and I met my friends Steve Zack and Kendall, Coffey. And, you know, one of the messages I want to leave you all with is, you can get involved in stuff like this, just spontaneously. It just happens because you're there and you want to do some good, and it's a lot of work. Nobody paid us, but it was very exciting. And also, you get to litigate against friends. He is not my enemy. He is the legal adversary in the courtroom. He is not my enemy, neither is Kendall or Ben. And, you know, I want to impress upon that because you all read a lot, what's going on in the world. We don't have to hate each other to be on different sides of the V. You really don't. And as you can see, I worked for this guy. Kendall and I became friends during the whole U.S. Attorney transition process. Ben I've litigated with and against. And Marcus and I go way back, and I go way back with this lady as well. So it was a fun time. If you get involved civically, volunteering, things will come your way. You can make your own destiny by just working hard and getting to know people, getting along with people. Anyway, there's more details after that.
Thank you. Mr. Zack?
Well, if you haven't noticed already, there's kind of a string that ties us all together. Maybe imaginary to you, it's very real to us. And it happened because we cared about the law, and we cared about justice, and we knew that we could trust each other. Now, I'm gonna tell you stories that you have not read about. There's been so much written about this trial that isn't known, and I will share with you some of those that statute of limitations have run on. And the way I got involved is I told Al Gore I didn't have time to represent him. 3 times, as a matter of fact. He called me the night of the election. I knew Al from when he was governor, and he called me the night of the election, and this was when Bush had been declared the winner. And I told my wife I'm going to sleep, and she woke me up. And she said, "There's a guy on the phone for you. He'd like to talk to you." So it was Al, and he says, I quote, I remember the words exactly, "Steve, it looks like we're gonna need some lawyers in Florida." Those were the exact words he said. And I said, "Love to help you, I'm busy." And I was involved in a class action lawsuit and other that. I said, "But I'll get you some lawyers." And that was it. So the next day, or a couple of days later, I go down to Don Middlebrook's courtroom, which was the first federal judge, and we were close to the University of Florida, to see who was there. And I got the last seat in the courtroom, and then they closed the courtroom, and they had to pump to another courtroom. And who do I sit next to? My good friend, Kendall Coffey. And Kendall says, "Steve, we lost yesterday in the canvassing committee. Will you re-argue it for us today? It's an hour." And I said, "Kendall, I'm busy." He said, "It's all on my," I remember this, "it's all on my conference room table. It'll take you 15 minutes to get prepared." One of the biggest cases in the world. And I said, "Kendall, of course." He said, "By the way, who's on the other side?" "Oh, Bobby Martinez." I said, "Well, now I'm in trouble, because he's one of the best lawyers I've ever known in my life." And
You trained me.
Well, the student's always better than the trainer. But so we go to court, and it was a 2-1 against us, and I argued it. And first of all, you go to canvassing committee room, it's usually in a closet with a bunch of people with tennis shoes on, and it's nothing.
Not this one.
This one, I walk in, and it's at least 150 movie cameras around the world. It was also highly shown because it was the same time as the playoffs for the football league. So people would go back and forth between the trial and the football league, back and forth. So over there, 150 cameras. But what I don't know is I am now hired by the Dade Democratic Party through Kendall. And what I don't know is that my future partner and good friend, David Boies, has been hired by the National Democratic Party and is in Tallahassee watching what's going on. All right, and we had a great argument back and forth. Bob did a great job. I was able to flip one person, and it became 2-1 that we're gonna have her handcuffed. And as I'm walking out of the courtroom, I get a call from David. Steve, this is David, I want you to come up and try it with me in Tallahassee. At this time, I don't say no. I didn't even ask him what I was gonna do. You know, carry your briefcase, David, I don't. So I get up to Tallahassee, and you can't even have a room, remember? Nothing. I thought it was David. Anyway,
That's Al
yeah, by the
Gore,
way,
that's Al Gore.
So, what do is you're a trial lawyer. I've never seen a vote-o-matic machine. So I get on a plane and I come back to Miami and I talk to Harvey Rubin and I said,
He's the clerk of the court.
The clerk of the court at the time. I said, Harvey, take me to one of these vote-o-matic machines. Take it apart for me. I gotta understand how it works if I'm gonna cross-examine somebody. This is trial lawyer stuff, okay? So people always ask how I found the chads. And how I found the chads is when he took it apart, he told me that it hadn't been cleaned for years. And they're supposed to, there's a punch hole and the chad goes through and it builds up. Well, if they don't clean it, there's no way for the punch hole to get through. And that's how you had those hanging chads. So now you know the background story. So, any event, I learned how you did that. And then the judge gave us 1 hour for each expert. And we had phonetic changes in the transcript, nothing actually written. And at the last minute, I asked, for some unknown reason, I asked the expert on the other side, have you applied for any other patents? And he said, yeah, I applied for a patent for a better punch hole. That was it. I didn't think anything of it. So I take the first expert and I get killed. And the second one, who I was scared to death of. Honestly, I'm usually not that, but this guy looked like Moses and he sounded like Moses. And anything he told you, you would believe right off the bat. And I asked someone in my office to go to the patent office and see if there was a patent for the next one. Wow. The courtroom is locked, you have to understand. Nobody can get in the courtroom because everybody wanted to be in the courtroom, so they closed the courtroom off. So the counsel table was locked away from everybody else. So I'm getting up to do the second cross-examination, and I'm dead in the water. I don't have any idea what I'm gonna say. This is typical, by the way, as a trial lawyer, you know, for some reason, when you're in trial, everything works better, or it doesn't work at all. So they lay a white envelope, I don't have any, nobody knows what it is, next to me. Now, being curious, I opened it up, and it's the patent on the vote-o-matic machine. And on the fourth page, and by the way, total grief to me, no idea what he's talking about. But on the fourth page, about a third of the way down, it says, in a close count, you need a hand recount. And I go up and I cross-examine the guy. Short cross-examination. The New York Times publishes the entire examination.
The judge is looking for it, she can hear you.
The New York Times publishes the examination on the front page of the New York Times the next day. And Al calls me and said, we won! And we were walking down in Tallahassee, go to Andrews, TV set says that the 11th Circuit has confirmed Middlebrooks, and then the Supreme Court accepted certification.
So we'll get to that eventually.
That's it. I'm done. But that's the beginning of the end.
Okay, Mr. Jimenez.
Hold on, I'm gonna do a political impersonation.
I don't know, you think they got that?
I don't know.
Marco Rubio.
So we're-
There you go, good, all right. One person.
I wanna ask a question first. How many people here do not have like sentient, independent memory of Bush v. Gore? Like you were too young?
Do not.
Do not, right? Okay.
Did they know this is me on the bar exam?
Well, I know we're supposed to talk about our own.
Yeah,
thing.
go.
Bush v. Gore wasn't one case, it was like
Yes.
5 or 6 federal cases, and then there were a lot of other little local cases, not little, but
Yeah,
local
it was limited.
canvassing
Good
board
camp.
cases. And it was 4 years of litigation done in literally 4 weeks.
Yeah.
And, you know, there were hundreds of lawyers, at least on our side, on the Republican side. So it's very difficult to talk about the scope, but I'll tell you what I did. So I was a partner at White & Case in the Miami office, which was small at the time. And my brother Frank was Jeb Bush's, the Governor Jeb Bush's acting general counsel, so he was his lead in-house lawyer. So my brother, I think my brother knew at 3:30 a.m. that there was gonna be a recount, or that there was gonna be a dispute over the election. So the first thing my brother did is he called up Barry Richard and got him out of the shower at 5:30 in the morning. Barry Richard is, I think, still, right?
No, he's on his own now, so he was a partner at Greenberg.
He was a very prominent appellate lawyer in Tallahassee for Greenberg. I think that's how Rocky got involved. And Rocky and I had worked at that firm when we were young lawyers. And then I worked with Bob. He was my boss when I was in AUSA. And then before that, I worked with Kendall when I was at Greenberg. He was my first boss and mentor, so I owe a lot to them. And so, you know, we are all connected.
You taught these guys too well.
Yeah. So the first thing I was asked to do was to go to Broward at 6:30 in the morning and see what was going on, see if they were actually gonna start counting. And I was looking through windows, and then they closed up and said, no, we're not gonna do any counting today. So I left Broward, and I was on the phone with my partners in Washington, George DeWilliger, who was the Bush 1 Deputy Attorney General, and that's how our firm got involved.
Ted also was involved, was it?
Yeah, then our firm and Gibson Dunn became the first two big firms to represent the Bush side. Ted Olson was with Gibson Dunn, and I think his entire career, other than when he was Solicitor General, and was a phenomenal Supreme Court advocate. And the first thing I did was work with Gibson and my partners in DC to file the first lawsuit, which was called Siegel versus Lepore, because at that time, the candidates didn't want to use their names. And I'll tell you something that is not publicly known. After we prepared the complaint, and I personally filed it, we filed it in Miami, even though it was a Palm Beach case, because we were trying to avoid the press. I drove with Ted Olson to the initial injunction hearing in front of Judge Middlebrooks. And so I walked in pretty much by myself, and I don't know what happened to Ted. He like disappeared.
Was that in Palm Beach?
No, this is in Miami.
No,
Yeah,
no.
Central courtroom.
So we filed the first, that was the first Bush v. Gore lawsuit. And the reason why Ted was not with me, and I had to sit there and tell the judge to please give us time, and there was all these lawyers including Kendall, and I think you were there too.
I was.
And, you know, Larry Tribe and Dershowitz, you know, they had this whole thing, and it was me on the other side, and I said, Judge, you know, we just need a little bit more time. The reason why we needed time is because Ted was in the bathroom, and he was on the phone with the governor, and the governor was telling him he did not want to proceed. He wanted to not go forward with the lawsuit.
Wow.
And Ted explained to him, sir, I'm in the courtroom. We filed a complaint and a motion for TRO. I'm going in. So that's how. So I stayed in Miami the first week while Judge Middlebrooks denied relief, and then we filed the appeal to the 11th Circuit, and then I went to Tallahassee to the Republican Party headquarters, which had been taken over by lawyers and press people for the Republican Party. And I spent the last 3 weeks there. Basically, what I would say I did was air traffic control, was to help coordinate what was going on between all the different cases, and you know, do random assignments. Like, for example, the case that ended up deciding the election started as a trial in front of a Leon County Circuit judge named Sanders Saul, who spoke with a drawl. Remember that? And our side flew in Bartlett and Beck, who are two of the best trial lawyers in the country. And here's a practice tip for you who are lawyers. If you go to the Bartlett Beck website and you go either to Bartlett's or Beck's bio, you will see Philip Beck's cross-examination of the expert statistician and the expert voting machine expert for the other side. And you don't have to go to a cross-exam course, just listen to those. They're each about an hour long, and you'll learn how to cross-examine people. So when those guys flew in, we knew that there was gonna be a trial. I spent, a day just educating them in the courtroom, and they flew in with a bunch of Supreme Court law clerks that had started at their firm, who are now partners. And I basically educated them and helped them. And I also worked on 2 of the 3 Supreme Court briefs that went up in different cases. And that's pretty much what I did. I mean, there's a lot more I could say, but that's probably the 5-minute version of it.
Mr. Coffey?
Well, I had the privilege of being involved early on. Early on, the view was to challenge the butterfly ballot in Palm Beach County. Now, that's not going to be a familiar subject, but there was actually a ballot that was really confusing as heck and probably illegally constructed, we would say, called butterfly ballot. And there was a goodly number of people, and affidavits everywhere were collected saying they did not mean to vote for that guy, Pat Buchanan. They had no interest. These were liberal elderly voters, and say it was a mistake. But we quickly decided, I got on for that. I was actually at a press conference with William Daley and Warren Christopher. But the strategy quickly pivoted to recount. The idea of trying to invalidate voters in Palm Beach County, 1 county out of 67, was ultimately said not to be very realistic. So
It was also approved by the Democratic Party, the
butterfly ballot.
Right,
Yeah.
that's right. The Democrats made plenty of mistakes, that's for sure. But it pivoted to count all the votes. Let's count all the votes. That was our theme over and over and over again. And it's hard to recreate how vulnerable we felt. We ultimately lost by 537 votes out of 6 million. But we still felt the whole time, or I felt, we were behind. We never caught up. The public wasn't impressed with the fact that Gore got, had a net national margin of about 500,000 votes around the country. We had to keep going somehow, show some progress, and at the same time, not lose our base of support. The first time a Democratic senator stepped up to a press conference and a microphone and said, enough already. This is the presidency of the United States. Get these lawyers and their images of briefcases out of here. Let's get on with the business of the country. So we had that hanging over us every moment. I think all of us felt that way. We never got ahead in the case, but we had some significant victories along the way. The first victory, which I had the privilege of participating in, was an injunction hearing before Judge Middlebrooks. And frankly, the Democrats were so confident of winning that because the constitutional issue presented was you have to have standards to do a manual recount.
Yeah.
You can't just say the intent of the voter, determine the clear intent of the voters. No, you gotta have some specifics. And the law today does have, in terms of the way you mark these optical scan ballots, criteria. It didn't then. But we said, so what? And that was my part of the argument. Again, that's overconfidence when you have Kendall Coffey step into the courtroom on a case like this. Fortunately, some guy named Lawrence Tribe was also stepping in and doing the major part of the argument. But our point was, well, we have different systems, different counting all around Florida. We always have. Some machines are optical scan, some are just fill out the paper, and it's never been a requirement to have a consistent standard. So we thought that equal protection argument was going nowhere. I have to say as an aside.
That's what we came.
That's what you came up, you
Yeah.
kept up with in the first game. And by the way, Mark got me a copy of the complaint, which elevated my status enormously. Wow, you got this complaint from everybody. And Bob Martinez also would give us a heads up, including our Sunday hearing over the chads falling on the floor. A lot of things we could talk.
Kendall, will you talk a little bit about the experts? With dueling experts, some wanted us to have just a county recount, and some wanted a statewide. And we didn't know which was better for us. And we had people continue arguing back and forth what we should even argue.
Yeah, no, we never knew. I mean, we get to a trial where statisticians, and neither side presented a statistician that said, we're probably gonna win. It was that ridiculously close. But I just wanna touch base on this argument about, I mean, come on here. You gotta have exact standards for recounting manually? Well, son of a gun, that argument didn't seem to have a lot of traction at the beginning. Judge Middlebrooks rejected it pretty quickly. We kind of thought, well, this is gonna be decided under state law. We've gotten past that, but for reasons that we can talk about, and we may have time to talk about this evening, that argument, which we kind of batted off and knocked out early on, became the difference in the history of the United States when the Supreme Court concluded, as I think they did. You gotta have standards for a manual recount, and you folks don't. And for that reason, they shut down the recount, even though we kept it alive. We kept saying, count all the votes, count all the votes. I think the Republican theme was, come on, these hanging chads are ridiculous. And the hanging chads, the dimple chads, you can't decide the presidency on something that is a silly looking piece of paper that has pieces poked out. And once the hanging chad, instead of our view, it was the instrument, a sacred instrument of the voice of democracy. And once that became a joke for late night comedians, we basically started to lose the public.
Can I just add one little thing?
People started naming their kids Chad.
So this will make Kendall feel a little better. So when we filed that first complaint, and I walked down to the courthouse and met the clerk who filed it, the equal protection argument we made was not focused exclusively on the standards to be used in how you manually recount a paper ballot, because it was a little different. What we argued at the time was that the recount that was planned was only recounting Palm Beach, Broward, and Miami-Dade, and not all 67 counties. So we didn't like that because at the time, unlike today, Miami, Broward, and Palm Beach were heavily Democratic leaning. So we didn't, if there was a recount, we didn't want to recount for just those three counties. We wanted it for the whole state. So that's what we argued at the time. What happened later was, and I'm skipping a lot here, but eventually the Florida Supreme Court ordered a recount of all 67 counties. And we said, you can't do that because there are no consistent standards for recounting, either in the statute or even between the different canvassing boards. Some canvassing boards use one method and other canvassing boards used another method, and that was an equal protection violation that infringed on the people's right to vote, because some votes would be counted and some votes would not be, depending on which standards, which were not uniform, applied. So you didn't really miss the argument. We refined it.
But it changed history, yeah.
Quick
I
aside, as
supplement what-
David said in a press conference, the Supreme Court of the United States will never take this up. Never,
That's
ever
true.
take it up. This is a state issue. They're not gonna touch it. Wrong.
Before we get to Ben, Rocky.
Yeah, so count all the votes, that was a byline, but that wasn't what the Gore campaign was doing. They wanted to count the votes that were more Democratic. And then later, when they were, correct me if I'm wrong, Mark, when they were at the state Supreme Court, they just wanted, there was a deadline for the appointment of the electors coming up, December 12th. So they said, only count the overvotes, only count the undervotes, not even the overvotes. And by the way, all the Miami-Dade ballots are now in Leon County. Leon County, Ion Sancho, supervisor of elections, who hasn't used punch cards in like 2 decades, you're gonna count the Miami-Dade ballots. So it was a mess. And I think the Supreme Court had the US Supreme Court had a lot to say about the only counting the undervotes also.
Well, David Boies was right. The Supreme Court had never, ever gotten involved in a election contest before that case.
And the opinion ultimately says they don't wanna do it again.
So we're talking about 36 days, November 7th until December 12th. The fate of the world held in the balance for 36 days.
Well, I don't know about that.
And December 12th, it was over. That's one of the things that you learn the lesson here. It didn't progress for months and months. The will of the Supreme Court was accepted whether politically they liked it or not. Election day, I am at the Fontainebleau Hilton with Bob Butterworth, then Attorney General and campaign chair for Florida for Gore Lieberman. Gore is deemed the winner. And all of a sudden, footnote, the governor of the state of Florida had declared that Florida will be delivered for W, his brother. And all of a sudden, the news media pulls Florida from the ranks of Gore. Bob Butterworth and I say, something's wrong. He makes some calls. The next morning, Kendall, Coffey, and I are flying to Tallahassee, where we meet with Secretary of State Warren Christopher, the overall chair of Gore Lieberman, and Mayor Richard Daley, who, by the way, comes from a jurisdiction that knows about voting. And Kendall and I provide a primer of Florida law on election law recounts to these two people who have no clue what Florida is all about. We give some advice, and we're told, okay, conversation, not with us, we're just young lawyers with the vice president, known at the time as the future president of the United States. And we're told, we'll be back in touch. Kendall and I go back to Miami, and the whole process starts with a client very involved who made some decisions. Media knows about it, we've talked about it. Some decisions directly against what Kendall and I advised. But ultimately, they came around a little bit too late on some of them, like statewide recount versus localized recount. Big, important decision. And as you know, on December 12th, the Supreme Court essentially, well, before that had stopped the Florida Supreme Court from ordering a statewide recount, saying there wasn't enough time to do a statewide recount. Politically, an issue. Then begat litigation that's both bureaucratic, canvassing board activity, and if you want to see how quaint things were, that is a voting machine used in most of the counties in the state of Florida at the time. Punch card voting machines, and if you want to see, these are Chads taking from the voting machine. The world decision on the president
Does everybody know what the
hung
Chads
on
are?
the fate of these little computer chip cards that were either punched or not punched from ballots. Seems quaint, but there were a lot of technology issues involved in it. And we proceeded to, from a lawyering point of view, you should all know, remember what year this was. Not the internet where you communicate with everybody immediately. Both sides put together law firms essentially overnight. Lawyers put out the call. Now, of course, it's wintertime, so when you make a call saying, come on down to Florida and help us, what good lawyer is not gonna come down to Florida? We put out the call, and on the Gore Lieberman side, Kendall and I, and primarily Steve Zack and Mitchell Berger, put together a law firm to represent Gore Lieberman, Team Recount. Unbelievable work. Litigating 13 different cases in different jurisdictions at every level. Kendall and I were fortunate to handle cases at every level, including the trial in Tallahassee, which, let me give you a perspective. I've told you the fate of the world hung in the balance in 36 days. We are trying a case in Tallahassee. I don't know how many of you have been at Tallahassee. I'm a W, so not so much with Tallahassee. But we walk out of court, all the lawyers walk out of court one day. Media is following. And what do we see when we walk out of court? The Tallahassee parade with Santa Claus coming to town. And that put a perspective that the world is really going on while we are fighting over the fate of the world. And all we wanted to do in Tallahassee was get Judge Sauls to rule. We didn't care how he ruled. We wanted him to rule. Get an order that we could take up, because we knew this would be decided at a higher level. Florida Supreme Court, remember, we won in the Florida Supreme Court. We won in all the Florida courts. Supreme Court, we didn't. But the idea was, get this matter processed to the higher court as fast as we could.
Ben, talk about the fact that, you know, in the normal world, you got 30 days here and 30 days there. When you walked into Saul's courtroom, you actually had a brief in your back pocket, done, and you walked across the street and filed it a minute later. I mean, that's the timing.
And
then
no
when-
electronic filing in those
When
days.
we went to, when we called the third DCA, when they had to review the original, they said, it wasn't like, you know, we'll set your date. It says, come on down.
Right?
And then we had helicopters following us the whole way, and then we had to, then Greenberg actually filed a answer to the complaint, and they said, don't leave, we're in the library, because you're gonna have to answer them immediately.
Yeah.
I mean, it's almost inconceivable, the timeframe you're talking about.
The point you made about you had your briefs ready, we knew you were gonna file the
Yeah.
petition for writ of mandamus. We were already working
Yeah, we knew it
on the
was okay.
response, and in the meantime, we were shipping the video from the recount to the third DCA as part of our defense. And then we got the response in, and a few hours later, Judge Schwartz, he leads with, writ of mandamus, it will not compel a futile act. This is futile, petition denied. Something like, it was pretty
It
brief.
was, no, it had to, we're not gonna even rule, give it to somebody else.
Yeah. And then on Thanksgiving, you guys went to the state Supreme Court, and I hear about it in the morning. I said, I gotta go to the office. So we're at the office again on Thanksgiving. We had just had our victory drinks the Wednesday night.
I had dinner with Paul Jr.
Yeah,
and Paul
that night.
Jr. and
Yeah.
Barbara at our house.
But that morning, so we're back at court, and I get a call from Barry Richard. Hey, you need to call this lawyer at Gibson Dunn. His name is Ted Cruz, and you got to do the pro hoc vice for him and for Ted Olson. I go, okay, hi Ted, how are you? Yeah, hi Rocky. So I entered appearances for Barry and for me, and I moved to pro hoc Ted and Ted, the Teds.
I want to
And
follow
then,
up on one thing that you said, it's so important, maybe the most important thing, how we weren't enemies. You
Yeah.
know, David Boies and Ted Olson were on opposite sides,
Mhm.
and they handled the same-sex marriage
Mhm.
together,
Yeah,
and they did things together,
yeah,
despite the fact that they may have been on opposite sides politically.
yeah.
It's just not fair to a country or to a profession not to handle it in that way.
And I want to echo what Steve and Bob have said about the professionalism. One night during all of this, I think we were still at the canvassing board. It's like 1 or 2 in the morning. Ben calls me on my cell. You remember that, Ben?
I do.
And I forget what you needed. You had a question, you wanted to know something. We talked it out. You got what you needed. And I think in 2012 with Romney, we we relived that moment on election night. Because that was one where it could have gone to a recount, and but it was before election day, and I remember like it was like 11 or 12 o'clock at night, we're on the phone again on another presidential election.
On that note, did you have PTSD?
No, you know, that was one of the greatest experiences of my life.
So you
I'd
wrote,
do it all over again.
You wrote in a University of Miami Law Review article called Reflections of Another Bush versus Gore Lawyer. You talk about the compressed time frame that Ben talked about at great length. It's really hard to believe all of this happened in such a short period of time. Can you tell the law students primarily how you were feeling during that time, how you handled it, because there was so much action happening? Were you sleeping? What did this do for you professionally and personally?
Well, first, I made sure that I fed everyone. My priority when I got, and I was actually doing real legal work, but my priority when I got to the office was make sure that I have lunch ready for people to eat and dinner ready for people to eat, because the Army runs on its stomach. So that was one, and I made sure that I ate. I made sure that I slept, even if it was only 3 hours, 4 hours, 5 hours. No matter what, I made sure that I tried to get some sleep. I was so thankful to be involved in such an important case, and particularly for a family that I admired for so long. I was a volunteer for George H.W. Bush when I was a college freshman here at UM in 1980 in the primary. So I just felt privileged that I could be here. And yeah, it was really stressful, but working with amazing people like Bob and Miguel de Grande, who was part of our team, and Frank Shepard and Barbara and PJ, and I mean, so many people that and so many people wanting to help. I mean, it was fun to have a former Scalia clerk across my desk saying, okay, what do you want me to do? And I would send him on, go get declarations of these people who filed absentee, who voted absentee, or go do this, go do that. And here's a really interesting story that you guys heard about the Brooks Brothers riot. Has anybody talked about that?
Between floors.
All right, so what a lot of the press and the Democrat Party blamed the end of the Miami recount. And I'm straying, but this will kind of give you an idea of what the stress was like and how you react. On a group of Republicans who started pounding on the door when the county was doing the machine recount in closed quarters and nobody could observe what was going on. And so in the middle of that, it's like, I don't know, I think it's like 7 or 8 in the morning. I get a call from Joel, the former Scalia clerk, who, by the way, ended up being the head of the Office of Management and Budget under W in his second term. He really, now I think he's a lobbyist for Meta. And he had worldwide government relations, I think. Anyway, he says, Rocky, we gotta do something because we can't get access to hear what's going on in the counting room. We can't see what's going on. Can you go file a lawsuit? I said, Joel, there's not enough time. It's gonna take a while to put it in. I don't think a judge is gonna, do anything with it. And I go, is the press there? He goes, yeah. I said, get the press to sign a petition or something. Get them to complain, because they couldn't hear or see anything either. So that's what he did, and that is what caused the county supervisor's office to move the recount downstairs to the public area.
Remember, they were between floors, and you put the Brooks Brothers guys in between so nobody could move, and then you brought in trailers that you put those people to sleep in.
I don't know, I didn't know anything about them.
I remember that.
But anyway, I asked the deputy supervisor, do you remember her name? She was amazing, a blonde Cuban lady.
Yes.
Anyway,
Welcome to the course.
a week later, I said, hey, I've been hearing a lot about,
She was very good.
you guys being intimidated by these guys in khakis And she's like, we couldn't even hear anything. We were in the back, we couldn't even hear them.
Also, you should know, if you've been in front of the Capitol, there's a big area right in front of the Capitol. And there was TV stations from every TV in the world. And they'd have a gauntlet. And they required that we send somebody out to talk to them every day. And all they wanted to know is what we were gonna do the next day. So we sent anybody that knew nothing. The most important thing is that they knew nothing we were gonna do. But we ran that gauntlet every day.
Yeah.
Bob, you wanted to?
I do, I wanna say something, that, I wanna give a shout out to another person, the Vice President, Gore. He conceded. He was the Vice President of the United States. The Supreme Court rule, he respected, he conceded. Now think about that.
Yeah.
Think about that. We all have different experiences. So mine was just at the canvassing board. Then I was there because I was a lawyer, very close to Jeb Bush. I wanted his brother to win. I believed in the cause, but I was there as a lawyer. I was not there as a politician. There did come a point in time in which there was some tensions between the lawyers and the political people running the campaign. Don't think that there wasn't. There was, okay? And there were some conversations that they were having without us. I'm sure they were saying among themselves, those guys are a bunch of wimps, they should be doing this and that. We didn't.
I know they said it.
I did, yes, I did, I know who said it too. I did not want to go there, okay? And, but it was friendly. I mean, it wasn't like the atmosphere, the rancid atmosphere that we have today in politics. I remember going once to Broward County, because I wanted to observe what was going on there. And there was a bus that was, people were kept in this bus, and they were passing out these posters that I thought was pretty cool. And I thought, you know what? I think I want one of those posters just for posterity, so that one day I can show it to a class at the University of Miami Law School. So here it is, and these guys will remember it. And this is about as offensive as it got, guys.
Oh, yeah.
Oh, yeah.
That's about as offensive as it got.
I remember that.
You know, so, you know, but it was, yeah, the lawyers fought, and
It's a
they
little
fought.
more extreme now.
Yeah, a little bit. The lawyers fought, and we fought very hard. You know, the politicians do what the political people do, the political operatives. But among us, we were there as lawyers. All of us here have been involved in various times in our lives with political people, political operations, government operations, but we're lawyers, we're litigators. And we were there doing our roles, representing our clients. And we, you know, it was quite an experience.
I want to run through this side of the panel with some concluding thoughts and then allow for Q&A, so.
Sure.
Mr. Jimenez?
You make me sound bold.
Well, it was a quarter of a century ago.
Well, I mean, like I said before, you know, I was in Miami the first week, but then from that point forward, I actually brought some show and tell stuff too. So let me show you. You might think some of this stuff is funny. So I went up and stayed with my brother and ran out of clothes in 3 days and came back for more clothes. But this is a sign that was on the 3rd floor of the RPOF headquarters. This was our law firm.
Hotel Tallahassee.
And it says Hotel Tallahassee, and then below it says, you can check out anytime you want, but you may never leave. And, you know, I have to say, we were, for having, you know, 3 major law firms, because Baker Botts was very active, White and Case, and then, of course, Gibson Dunn, and then there were lots of other firms like Bartlett Beck that came in to do things. We had a very, as you can imagine, it was run by a former military guy, a guy named Jim Baker, who was a formidable man and politician and Navy veteran. And he would come in his Navy track suit, and he had a group of 5 or 6 people under him that he kind of directed, and then those 5 or 6 people had other people that they directed, and I was in there somewhere. But it was still, even though it was still very well organized, this was one of our filing systems on the floor. You can see that. Those are different cases, different briefing.
It's the same logic as
things.
Microsoft Word.
And here's another picture. So, you know, but you know, the thing that struck me.
Wait, what's the one, what's the other one you just put?
The chaining one.
Oh, this is Terwilliger's daughters did a thing for him. It's pretty funny, but, so we, you know, like I said before, we did things incredibly fast paced and people turned out incredible work product. When the last case went up on appeal to the Supreme Court, which ended up deciding the election, we actually filed a motion to stay the Supreme Court's order that had permitted the recounts to continue. I think that was on, I'm gonna just guess, December 8th, December 9th. The Supreme Court granted the stay the next day, treated our stay as a petition for writ of cert, and gave us 24 hours to file a brief the next day.
Supreme Court.
And, you know, we all just stayed up, I remember that night, we all stayed up literally that whole day, that whole night, and then filed the brief at the end of the day. And it had to be, you know, a real Supreme Court brief. It's not just like a typewritten memo that you do on Microsoft Word. You know, you have to comply with all the rules.
How many people worked on it?
In those 24 hours, there were, you know, I'd say at least, you know, 15 or 20 people working on it, lawyers working on it. I mean, there were 2 or 3 principal people doing it, but, you know, we would all split up different sections. And you know, I was just doing a little bit. I felt like I was Forrest Gump. I was just kind of editing, and I was very happy that I got one of my sentences, you know, in the brief, and it ended up being quoted in the, you know, reproduced in the New York Times the next day. So that was pretty cool. I said, hey, that's my sentence. But you know, it was an incredible experience. You know, really to see lawyers operating on both sides at their best under tremendous pressure, involving, you know, the super high stakes, like the highest stakes imaginable. Who's going to be the leader of the free world? I think is what your point was, Ben. And it was, you know, I think initially at least it was a reluctant thing for both sides. Nobody wanted this decided by the courts. I think both sides would agree with that. And it's a very big contrast to what happened in.
Depends how they decided it.
Yeah. It's a very big contrast to what happened in 2020 when, you know, there were, 50, or 2019, whatever that was, 50 different lawsuits, 60 different lawsuits filed by the Trump side and involving lawyers all over the place. And, you know, I want to choose my words carefully. They weren't the same lawyers who were involved.
Mark,
in Bush v. Gore.
Mark, you're my friend. Enough.
So
No seasoned election lawyer took the case, let's say that.
yeah. So it was. I'm just saying it was a very different experience. Like when we were involved, I think people literally did not, you know, I think just did it because it just ended up being that way. It wasn't a deliberate tactic, let's say. So. But it was an incredible experience. It really was a highlight to work with great lawyers and on both sides and see that operation and how.
I think your statement that nobody got paid, they did it because it was the right thing to do, is amazing. It says a lot about our profession.
Yeah, I think you know, we went into it not thinking we're not going to get paid. I think maybe at the end the campaign reimbursed some law firms. I don't know. That was beyond. That was not in my scope. But you know, on your point, the chairman of White & Case at the time, who was an old Wall Street lawyer named Dwayne Wall, actually called me on the phone and he said, "Are we going to get paid on this case?" and it was early on. It was like in day 3, you know, on November 10th or whatever. And I said, I have no idea, but this is really important, and I think the firm should do it. And you know, to his credit, he allowed the firm to do it. So
I want to be clear, we got paid. Joe sent us stone crabs.
Mr. Coffey?
I think you can tell from this discussion what an intense and incredible, at times exhilarating, and for us, we lost, ultimately shattering experience it was. I mean, I remember it was a Friday that the Florida Supreme Court had ruled favorably. so what would that be, around December 8th?
Yeah.
Yeah, December 8th.
Yeah.
The next day, we all collected, and I remember this massive phone conference because the statewide recount had been ordered. Thank heavens, because if there was any mistakes we made, and there weren't many despite the intensity and the fast pace, maybe we should have asked for statewide recount from the very beginning, because they kept pounding us with that, and the press kind of thought that was a valid thing. And I thought, well, the Supreme Court of Florida bailed us out. They ordered a statewide recount. So I was driving to Sarasota because I was going to be in front of that canvassing board to do the state recount. We all divided them up. And there was this massive conference call with all these people checking in, and it was so exhilarating. And then I got the call that said, the recount has to stop. The vote counting stops because, of course, the stay had been granted. And professionally, it's got to be the lowest point I can recall. So that's just something.
Kendall, who ran, from the Republican side nationally, Tim Baker was a guy who I believe, called the shots. Who did it from the Democrats?
Ron Clinton.
Unclean.
Yeah,
Ron
he
Clinton.
was the boss. David Boies was lead counsel. So, but I want to come back to, it sounds like there's a love fest up here, and maybe there is. There's huge amount of mutual respect. But it isn't just the mega once in a lifetime, once in a century case. Every case you're involved with is going to make an impression on your co-counsel, is going to make an impression on the court, jury, but also opposing counsel. And everybody who's up here has benefited my career since 2000. Everybody. And that is going to have the same potential for you. And it doesn't have to be a presidential recount case. It can be a mortgage foreclosure, it can be a slip and fall, whatever the case is. But bear in mind that you are defining you, and that to just be selfish about it, you gotta be aggressive and do your utmost for the client. But you can also do the utmost for the profession, which is the utmost for you. The final perspective is the vote count. The Supreme Court of Florida ruled for us 4-3. 4-3. And the press have been blasting away at how this was filled with Lawton Childs, the Democrat appointees. The U.S. Supreme Court ruled against us, 5-4.
Well, it was 7-2 on the substance.
On part of it, but 5-4 in terms of the ultimate
We always
outcome.
thought we had Kennedy at the end, but we were wrong.
We were wrong. And I mention that because I think to this day, the public does these votes. I mean, people say, yeah, this judge was a Obama appointee, or this judge was was an R or a D. And I think that experience may have permanently defined for the public sort of the political nature, or what they think is the political nature. We know better than that. I'm able to lose in front of Democrat appointees as well as Republican appointees. But the public sees the vote count, and that's the end of the analysis. And if you look at the judicial confirmations of Supreme Court justices, before 2000, Breyer, Ruth Bader Ginsburg, overwhelmingly, more than 90 votes, even though they were clearly liberals. After that, the numbers started dropping in terms of the consensus, because I think that, and it may be the legacy of Bush versus Gore, it may be other factors, but I think the public and the politics has gotten, frankly, much more into the vote count. And so 4-3 we won, 5-4 we lost. We lost an incredible experience, but as you can tell, for those of us on the losing side, there's a bittersweetness to it that we'll never forget.
Yeah, I agree with everything he said. The 5-4 vote, though, was on the remedy, right? Which, like, what do you do, right? Because the court 7-2 agreed that there was an equal protection violation, but there was disagreement on what to do about it. And two of the judges that voted on the 7 majority side voted with the minority side to stop the counting altogether. And just said, okay, let's just leave it at that.
Was there a majority opinion? Somebody that?
It was a per curiam.
Per curiam, yeah.
But and there were two. There was a Rehnquist concurrence, and then there were 2 dissenting opinions.
Interesting.
We ushered in election law, which now you learn in law school. Lawyers become proficient in it, and Bush v. Gore legitimized the role of lawyers in elections. First time ever. locally things were done, and now you see every campaign has a voter protection team, lawyers looking at ballots, looking at placement, looking at all the legal issues. In between elections, going to administrative agencies to talk about how the elections can be run fairer, reviewing how machines work. Yes, I know that we think that Korean paper was used for some of these ballots and some of this crazy stuff, but how it really works. The point being, lawyers, the role of lawyers can help people trust the election system. Trust at an all-time low right now. So that's one takeaway for all of you thinking about it. If you like this, maybe you won't become an election specialist, but get involved some way using your legal skills for a campaign or election. We've created that opportunity for you.
Judge, I'd like to, and at least my thoughts was, I was requested to go to the largest law school in China after, when I was president of the ABA, they invite you to these places, and they Google you before, because I always open it up for questions. And I'll never forget, 1,000 kids there, and this young Chinese guy stands up and says, "Mr. Zack, how did you like losing, less than like 15 minutes, Bush versus Gore?" And I'm sitting there, and of course I'm surrounded by government people as well, and it actually was not a hard question for me. I answered, I said, well, I learned that in the United States, when we have a problem, we turn to our lawyers and not to our generals. And that was my answer.
Nice.
Were you then ushered out?
Round of applause to our panel, I think that. We have time for a brief question and answer session. Does anybody have a pressing question they would like to ask? Oh, start over here.
I just have a quick one. What's the longest you guys stayed up without sleeping during that process? I mean, I'm so curious.
2 days?
Oh, we crashed.
I think people slept just not a lot, you know, you sleep 3-4 hours. Yeah.
The quality of work was so demanding that you could not be walking through this in your sleep. So everybody was encouraged to be active, but also make sure you got some shut-eye, whatever that was, because you can see from the writing, and lots of people involved, that this was crisp, good stuff that stands the test of time. You can't do that if you're half dozing.
But you know what? We had an advantage over you guys, and that is we did it all in person, right? We met in person, we were teams. No remote, it was in teams. I mean, you can work in teams, you can thrive on each other's energy, and it's actually less tiring to work in a team in person than it is talking to somebody remotely all the time. So, you know, we didn't think about not sleeping, we just did it. Just did
Question.
it.
You all described how it was kind of like setting up mini law firms when you were working on this case. How was it in terms of, I guess, assigning roles and how people kind of divided up the work or worked together, like with everyone having their own respective careers and
You have to have a
positions?
general, and David and Mitch Berger was also, and Kendall. I mean, they were the people, like, 1-star, 2-star generals, but they made a decision. We had a real problem. We had to finish the case at a certain time, and we actually took a calendar out and worked backwards as to what had to be done at certain points in time, or we were just gonna run out of time, and legislature was gonna appoint it, and that'd been the end of it, and we couldn't allow that to happen. But, you know, I think David and Mitchell and Kendall decided how we would proceed.
Yeah. and
I think embedded in that question was a lot of egos.
Well, you
How did that
know,
work?
Yeah, well, on our side, I already mentioned this a little bit. Jim Baker was, you know, technically the calling the shots, but there was I'd say a committee of 5 or 6 people who would meet with him every day. And we, the way we did it is we organized it, you know, David was, I think, doing just state and federal stuff, he was really going crazy, doing trials. I mean, David was everywhere, right? On our side, we said, okay, Ted Olson's gonna do the Supreme Court stuff. Barry Richard and Michael Carvin are gonna do the Florida Supreme Court stuff. Bartlett Beck is gonna do the Senator Saul's trial. And then we had Bigger Bots do the absentee ballots trial. And so we definitely spread our people around and focused in a way that I think was different than your side.
On the Gore-Lieberman team, you're right, egos, but I think most people will say that working with David Boies, with the exception of Steve Zack, probably the most brilliant lawyer that exists. And he would every day listen to what the lead lawyers had to say and not make any decisions until he heard from the lead lawyers, Kendall, myself, Steve, etc. Remarkable. He could have done this himself. And there's one little bit, talk about egos. We all know the reputation of Lawrence Tribe. He prepares a brief for us. And the brief going to the 11th Circuit, the draft that he says is the draft, it has the point, one sentence with a footnote. And the footnote, a law professor's footnote, goes the whole rest of the first page and the second page. So you're reading one line. And he has a justification for why it has to be like that. David Boies says, judges don't do that, and rewrote Larry Tribe's brilliant work. And Larry Tribe accepted it because he knew that we had to convince the court. We weren't just doing lawyering. And so it worked.
By the way, you only see the pebble in the stream because it has many ramifications. David and I were friends, but barely friends. We worked a little bit on other cases, but we've been partners now for 22 years. I mean, that's the things that come out of it. But the friendships that you have are lifetime friendships.
I only worked at the canvassing board and it was for about 3 weeks. I worked primarily with this lady here and four other lawyers, and it's just spontaneously, it's like a team. I happen to play a lot of team sports. So you kind of figure out, okay, she's the right wing, I'm the halfback, he's the fullback. It just kind of happens spontaneously. There really is not an ego thing. Same thing, Mark and I have done that before. Mark and I worked together representing class action, representing 40,000 refugees that were sent to Guantanamo. Kendall was on the other side, he was the US attorney. We just kind of mobilize as a team. You just do it, and you put you basically sit on your egos.
It was so incredibly important, Judge. We just wanted to win, honorably,
Right.
the right way. But the idea of needing this authorship or this credit, I may be missing something, but
Right.
it never occurred to me. I never saw it. Just how can we win? How do we deal with the deadlines, the onslaught of new events happening every hour, every minute? So I felt it was probably, of any major case, the least ego I've ever seen.
Going back to your question, Judge Miller, about how did I cope with the tension and all that, I just remembered something that kept me going. I thought about George W. Bush, President-elect Bush, and how hard he had worked, and how committed he was to his exercise and fitness and everything. I'm like, if he can do it, the least I can do is do this for him. And so he was kind of an inspiration for me about the way that he conducted himself and how hardworking he was on his own behalf.
It was a lot of fun too, guys.
It was fun.
a blast.
It was fun.
And
It was.
And you're doing it with friends.
But
It was a blast.
sometimes
It was more
you
fun
gotta
looking
reach out.
back- More fun looking back.
No,
Yeah.
it was a blast doing it.
I missed it when it ended.
It was,
Oh, yeah.
it was, you got some rest, but it was a blast. It was a lot of fun.
One more question? One more? Yes.
I don't know, you raised your hand before.
I think Judge Huck had
I know
his
Judge
hand.
Huck has his hand up, I'm not gonna call on
They're a
him.
lot more qualified than I am. So.
Your Honor.
I'm a law student too.
All right, yeah, I'm a 1L. So I'm a 1L when you talk about, wow, it's gonna be a lot more fun in retrospect. I very much hope that
It was fun. It was fun what was going on.
Yeah, exactly. It's fun. Yeah, it's fun.
Yes.
I actually was thinking about Mr. Coffey's point, and I guess all of you being here is sort of emblematic of this. In the beginning of this journey, I've heard I guess a saying that I wanted all of, or as many opinions on as I could get, and that is that the law is inherently political. That's something I've heard, and when I hear it, I'm not sure if I should encounter that phrase with a certain amount of like strategic pragmatism, or if that's something, as I hear it, as someone especially who believes in good work, if that's something that should be sort of rebelled against.
What do you mean?
The law is inherently political.
What does political
What do you-
mean?
what do
What do you think it
Exactly.
means?
I'm not.
Who said that?
I come at it with a couple different minds.
Who said that?
A few people have recently graduated, and
Well, we're functioning within a constitutional system that was
Yeah.
created by unelected
Yeah.
politicians.
so I'm curious, when you guys hear that phrase, does that sound like nonsense? Does it sound like?
I think it's overrated. I think the public perceives that.
Yes.
And of course, presidents pick people that they think reflect their judicial philosophy. Of course, they should, that's the Constitution. But to say that, especially with the federal judiciary, but with the judiciary broadly, to say that it's all about politics, I think is fundamentally wrong.
Elections have consequences.
But I hear that phrase and I hear it in the context that Bobby was saying, which is, it's a political system or philosophy that's created the law. And of course it's political because law is about making judgments, which are political, as to what you want to encourage, what you want to discourage, what kind of process you want, what kind of government you want. So I'm very intrigued by that phrase, and I would be fascinated to know what the origin of it was.
It all has to be anchored on the rule of law. Okay, so the discomfort that a lot of lawyers have, who believe strongly in the rule of law, with what's going on right now in this country, is that the rule of law may not be as respected as we would like for it to be. But we are a rule of law country.
Well, I see it a little differently. I think what you may have been told is that maybe judges are deciding cases, or politicians are deciding cases or laws based on their political philosophy rather than what the facts are and what the existing law is. And like I think for sure, someone's background and philosophy is going to influence
Of course.
decisions to some extent.
Experiences.
But Bob's right. I don't think it's the rule of law. I think it's respect for the rule of law, right? So we do have a constitutional system and we have a judicial system, and you have to respect that. And what you're seeing now is a little bit of both, and I'm not saying it's one side or the other. I think you have both sides attacking certain decisions as political rather than based on the law.
When you walk in front of the United States Supreme Court one day, you walk through a bunch of columns and you look up and it says justice under the law. It doesn't say, anything about opinions, not being Democrat or Republican. It is a system of laws. And that's what separates us. By the way, it's what separates us from the rest of the world. If you travel around the rest of the world, it's not justice, it's who is appointed by which person who's in office. And we want to avoid that happening in our country. But the rest of the world, completely different.
Judge Huck, final.
Not a question, I'll make an observation. As the oldest person here and having lived through this, frankly, I find this inside information fascinating, I really do. But for the student, I hope they take away two things from this. One is, as in life, the practice of law is all about relationships. And the sooner you learn that, the better off, and the happier you're gonna be, the most satisfied lawyer you're gonna be. That's one thing. The other takeaway is, and why I'm so proud of being a lawyer, and I love lawyers, I love being a trial lawyer, I love being a trial judge, because it's by far the best profession. No question about that. And tonight, you've seen the best talking to you about when they did their best. And this is a lesson you should, the people who came here tonight got a great lesson. I feel sorry for people who didn't take the time to come here and listen to us. This is what it's all about, folks. And this is what you have to look forward to.
Absolutely.
Look, our system of justice is not perfect, but it's the best one that the world's devised so far. And,
It's like what Churchill said, he said, democracy is a terrible system, except for all the others.
exactly.
Well, let's go. Thank you all.
Great art.
Law students, please take fruit on your way out.
For sure.